Okay, Mr. Seeger, you ready with Mr. Is it Bishke?
Mr. Bishop.
Okay. We'll go on the record in People versus Nicholas Bishke. We have file number 255135. The record should reflect Mr. Bishke's present here in the courtroom today. On the record in People versus
Oh, yeah. Okay, sorry about that.
Okay, Mr. Seeger, we've got this set for a status conference, but also a bond hearing. I believe Mr. Bishke was arrested for a bond violation since this case was found over. How did you want to proceed today?
Your Honor, as it relates to the potential resolution, we would just ask for an additional 30 days as we contemplate the offer, because I believe it's the first time that we've been in circuit court. We're still contemplating it, but we're likely to resolve the file. There has been a meaningful offer that's been made. In relationship to the bond violation, it was somewhat, I think, handled in district court, but I do realize that it was found over as well. The court in district court, which I think was somewhat related to some other matters, enhanced his bond to a lesser degree, for which he was able to post his bond. But then there was this corollary in circuit court, so I guess that's why we're here for that too.
Okay. Mr. Ziegler?
Your Honor, I don't have any objection to the adjournment being requested. I do agree with Mr. Seeger that we had a hearing in front of Judge Boudet on some misdemeanor files. His bond was addressed there. It is concerning to me that he had contact with the victim openly at a restaurant here in town for the public to see, and that he has repeatedly violated the terms of his bond by committing new offenses and by having contact with the victim. It's also concerning to me that the victim suffered some significant injuries in this case. The back of her head was, for lack of a better term, cracked open, had to be stapled shut. So the contact is concerning in this case. I don't know that more needs to be done. His bond was raised in the files. It was posted. We're now maybe a month out from the violation. So I would leave it to the court's discretion whether additional action needs to be taken in this file.
All right, Mr. Bishke, the court is going to set this for a plea hearing and status conference in about 30 days. Between now and then, you need to discuss any plea offers that are out there with your attorney and be ready for a final decision on that date, whether you want to enter into a plea or go to trial in this case, okay? With regard to the bond violation, I just want to make sure you understand that what typically happens didn't happen in this case because there was an underlying charge and the district court, as counsel indicated, dealt with the bond on that. But if you violate your bond in this file again, particularly by having contact with the victim, I'm simply going to revoke your bond in order that you be remanded to jail until the next hearing. So unless you want to sit in jail, you need to abide by these conditions. So the court isn't going to take any further action on the bond violation, given that, again, the district court has addressed that issue. But I just want to make sure you're clear on what's going to happen if that happens again. And then, like I said, make sure you stay in touch with Mr. Seeger so that you're ready to go forward at the next hearing. Do you have any questions at all?
No.
Okay, thank you. That's all for today.
Yeah.
Mr. Bertrand texted me and he was running away with the lady, said that wherever it was that he was traveling from, someone in Clement, so he should be here shortly.
Okay. Mr. Horowitz, were you ready with Mr. Evans' case? Record in People versus Evans, file number 234811.
Michael Horowitz on behalf of Mr. Evans.
Thank you. And the record should reflect Mr. Evans is present here in the courtroom today. This is set for status conference. Mr. Horowitz, can you tell me where things are at?
Your Honor, good morning. They're in the same place they were at our last hearing. The case is still pending in the Michigan Supreme Court on application. It is, I guess what I was trying to look at here, what occurred to me that I could look at is the timeline on the previous case that I know they granted, but the internet connection isn't working great. Because I don't really have at this point, I think a timeline expectation. I would have thought that the court would have already granted or denied based on the pleadings. So I guess at this point, it just makes sense to ask for another adjournment while it continues in that court.
Mr. Ziegler.
I agree with Mr. Horowitz. The court did direct me to file an answer to the defendant's application. I did that maybe about 2 months ago at this point. Still have not heard anything from the Supreme Court one way or the other. I think it makes sense, given that we've waited this long, to get a final answer from the Supreme Court before we proceed.
Okay. Mr. Evans, was there anything that you wanted to say regarding this matter? Okay,
Eventually.
all right. Then at this point, based on the positions of the parties that they would like to get a determination as to the application from the Supreme Court before we do further scheduling in this case, I think that's reasonable and prudent. So I'm going to adjourn this for 90 days or a decision from the Supreme Court. The court will get notice of that along with counsel. And so if that comes earlier than 90 days, then we'll proceed at that time. Mr. Horowitz, anything further on this file?
No, Judge, thank you.
Mr. Ziegler,
No, Your Honor.
Mr. Evans, did you have any questions at all?
No, sir. Thank you.
Thank you.
Go ahead, Terry.
Mr. Alhart, did you have a case you were ready with?
Not until 10 o'clock, I've got a case versus Fortuna. I hope you get started early, because I have other matters and Brandon Trevor's coming, but it is what it is.
Okay, yeah, as soon as he's here and you're ready, let the court officer know and we can take your case.
Here, I do have Mr. Bertrand here.
Okay, Mr. Bertrand, if you come up to the podium, please. We'll go on the record in People versus Bertrand. This is file number 255117. The record reflects Mr. Bertrand is present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of people, Your Honor.
Thomas Seeger, with an on behalf of Mr. Bertrand.
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Bertrand, did you have a chance to go through the pre-sentence report with Mr. Seeger and discuss that with him?
Yes.
Oh. Mr. Seeger, are there any additions, deletions, or corrections to that?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
They're not, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for elocution today?
Your Honor, it's fairly rare in these types of cases where the defendant gets a recommendation of fines and costs, and I'm going to support it, but that's the case here. I think Mr. Bertrand has done what he's needed to do. He's taken his problem seriously. He's sought treatment. I think in light of all of that, the recommendations contained in the PSI are appropriate. I would ask the court to adopt them.
Thank you, Mr. Seeger.
Likewise, Your Honor, I would just ask the court to consider following the recommendations. And I think Mr. Bertrand has taken seriously his need to refrain from using substances for which are not helpful to him in life. So I think he recognizes that. He's expressed a great want to remain sober. I think just like with anyone who has a substance abuse problem, there is a long period of wherein I think you struggle with making decisions. You probably struggle with your addiction. You probably struggle with stability, and all of those things are probably true for Mr. Bertrand. But he's expressed a want to remain sober. He's done a reasonably good job. He's been very good in terms of communication. He's just hopeful the court will follow the recommendation.
Thank you, Mr. Bertrand. Was there anything you wanted to say today?
Just that I've made some bad decisions and have moved forward, sought some medical treatment to deal with underlying issues, and seem to be doing pretty good.
Good. Yeah, I read through the report, so I'm familiar with what happened in this circumstance, and I'm also familiar with kind of your history, of course, but then what's happened since this charge. And it does appear to me that you have taken a lot of steps to try and address your underlying issues, which lead you to use substances which are not legal. And I agree with both counsel. I think this is the kind of case, you know, the court can sanction wrongful conduct in a number of ways. One is financial, which can be punitive sanction, and the other is, of course, incarceration. I think incarceration in your circumstance would kind of interrupt the positive steps that you've taken since this happened, and I think would cause more problems than it would solve. And so I think the recommendation is appropriate here, and that imposing a financial penalty as opposed to incarceration is a more appropriate resolution. So I am going to follow that recommendation. The court is going to sentence you to 8 days in the Kalkaska County Jail. You do have credit for 8 days served. A crime victim's assessment of $130, court costs of $325, fine of $100, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Seeger, if you can have Mr. Bertrand see if they can tell it right. Mr. Bertrand, these papers are going to explain to you how to seek an appeal as well as how to request help from a court-appointed attorney if you wanted to do that. And then after this hearing, Mr. Bertrand, you just need to go next door to the clerk's office, make arrangements for payment of those fines and costs, and good luck to you going forward.
Thank you, Your Honor.
All right, Mr. Travis, I think we're going to have Mr. Chisholm here from Wexford.
Miss, Your Honor, but yes.
Oh, Miss, sorry. Oh, yeah, Jasmine, okay. All right, Miss Chisholm, I just need you to unmute on your end there. There we go. Can you hear me okay?
Yep.
All right, and just to confirm for the record, you're Jasmine Chisholm, is that correct?
Yes, sir. Yes, sir.
Okay, so we'll go on the record in People versus Chisholm. This is file number 255123. The record should reflect that Ms. Chisholm is present today by video from Wexford County Jail. If I could have counsel put your appearances on.
Brian Ziegler on behalf of People, Your Honor.
Kyle Travis on behalf of Jasmine Chisholm.
Travis, can you tell me the status of this file today from the defense side?
Yes, Your Honor. We waived the preliminary exam in this matter based on a plea offer. That offer would be to a count of attempt felonious assault and attempt R&O. And Ms. Chisholm would like to accept that offer. And there is a minor issue. Alcohol was involved in this, and she can give a factual basis to the felonious because it happened earlier in time. But basically, by the time she made it into the jail, she doesn't remember what was going on anymore. So to the attempt R&O, we would ask for that to be a no contest plea.
Okay. Is there any reason why we couldn't just do both as no contest? I mean, is
I guess yes, Your Honor. That's we have a report for both. I just in speaking with her, she could probably give a factual to the felonious, but we can maybe a couple more pages of the report.
Mr. Ziegler, do you have any objection to taking both as a no contest?
I don't, Your Honor.
Do you need a minute to assemble that information, Mr. Travis?
I think I've got, I may give you a few more pages than you probably need on the other one, but I've got 4 pages here that I think should cover everything, if Your Honor would like.
Okay.
And just to correct one thing. I think Mr. Travis just misspoke, but the prelim was held in this matter. It was held by prior counsel. Mr. Travis took over after the fact.
Good point. Very accurate.
Okay.
I didn't hold the prelim.
Right.
Right. You were partially correct. Yeah, I mean, I think as to count one, even if intoxication isn't a basis for the no contest plea, I think certainly civil liability is an issue there. And so for the record, as long as everybody's okay with it, I think we make a cleaner record. Ms. Chisholm, were you able to hear everything we just said about this plea agreement in this case?
Yeah, most of it.
Okay, so what's gonna be, the offer is for you to plead to felonious assault as an attempt and resisting or obstructing as an attempt, and that you would be pleading no contest to both of those charges. Have you been able to discuss that plea agreement with Mr. Travis?
Once or twice.
Okay. Do you need more time to discuss that with him, or did you want to move forward with that agreement today?
I'm fine with moving with the agreement today.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Chisholm, are you currently on any kind of probation or parole?
No.
Okay. So by pleading guilty to felonious assault as an attempt, I'm sorry, pleading no contest as an attempt, the maximum possible penalty you could face would be up to 2 years and or a $1,000 fine. Do you understand that?
No.
And no contest to attempted resisting or obstructing carries with it a maximum possible penalty of up to 1 year and or a $1,000 fine. Do you understand that?
Yeah.
With those things in mind, what is your plea to each of those charges today?
I'm pleading guilty.
Okay, or no contest?
Mm-hmm.
I just need you to say yes or no.
Yes.
Okay. All right, so I'm gonna go through a few things with you with regard to your rights. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand that you have all of those rights?
Yes.
And you understand that by pleading no contest, you're going to be giving up and waiving all of those rights.
Yeah.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal this plea or get it reversed, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yeah.
Has anyone threatened you with anything to get you to plead no contest?
No.
Has anybody promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Mm-hmm. Yeah.
Okay. All right. Mr. Travis, have you reviewed? I'm going to mark what is labeled as State Police Report Incident Number 72-2199-25. Have you had a chance to review that report?
I have, Your Honor.
All right. And do you agree that the information contained within that report, which is a 6-page report, would establish a factual basis for finding of guilt as to attempts on count 1 and count 2.
It does, Your Honor.
Mr. Ziegler, have you done the same?
Yes, Your Honor.
Would you also agree that there's a factual basis based on that information?
I would, Your Honor.
All right, so I'm gonna mark and admit that police report as court exhibit 1. Just 1 second. All right, the court's had a chance to review that police report. I would agree that does form the factual basis. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis, are you?
Your Honor, I guess exposure, and I have discussed this with Ms. Chisholm. There was some discussion of amending the charges if we proceeded to trial to some more serious charges. But that would be all.
All right, Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Travis,
Yes, Your Honor.
thank you. All right, Ms. Chisholm, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of the attempted count 1 and count 2. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Between now and then, you'll meet with somebody from the probation department for a pre-sentence report. And then you'll have an opportunity to go through that with your lawyer prior to the sentencing hearing. Mr. Travis, anything further we need to address today?
Nothing further, Your Honor.
Mr. Ziegler?
No, Your Honor.
Ms. Chisholm, do you have any questions about how we're going to proceed forward from here?
Not at the moment.
Okay, all right, thank you. That's all for this hearing today.
All right.
Just attempts of counts 1 and 2.
Exactly.
Yes.
Thank you.
Okay, do we have Mr. Schilling present? Jonathan Schilling?
Well, I'm here on his behalf anyway. Do you want me to bring him in here, Your Honor?
If, yes, if he's here. Are you Mr. McCarty?
I am.
Oh. Mr. Schilling, if you can come right up to the podium there, please. Thank you. We'll go on the record now in People versus Jonathan Schilling, file number 255122. The record should reflect Mr. Schilling's present here in the courtroom today. If I could have both counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
And good morning, Your Honor. Attorney Jeff McCarty, P42633, on behalf of Mr. Schilling, stands to my right. Sir, could you please state your full name for the record?
Jonathan Jacob Schilling.
Thank you. We're present here today for purposes of scheduling and status conference. Mr. McCarty, have there been any plea discussions in this case?
There have not since the exam was conducted. I reached out to Mr. Ziegler, but haven't heard back in regards to whether anything has changed in that respect. But well, that's the long and short of the plea negotiations or discussions.
Okay, Mr. Ziegler.
Your Honor, the offer was made prior to the preliminary exam. It hasn't changed. It's an attempt R&O. And Mr. McCarty and I had discussed prior to the exam, looking into whether or not he'd be eligible for Veterans Court somewhere. My understanding was that they couldn't find a program or a placement where he'd be eligible because we don't have one here and there aren't a lot of them around. But I would have been amenable had he been able to get into a Veterans Court to resolve it that way.
So Mr. McCarty, did you want to go ahead and docket this for trial? And then typically what I would do is set a trial date and then have a final status conference, which would be a plea cutoff. Is that how you'd like to proceed?
I would like the trial date set. There is a motion that I am contemplating, but notwithstanding that, in the event somehow we were to further explore the Veterans Court, I could do so in that time period, but I would definitely like the trial to be set today.
Okay. If the court were to set this in, 90 to 120 days, is that enough time for you to be
Oh,
ready?
plenty. I mean, 90 would be more than adequate, I would think.
All right, Mr. Ziegler.
I would agree, Your Honor.
And do we need more than one day for this?
I wouldn't think so.
It's a one-day trial.
I'd be longer to pick the jury than to try the case.
Okay.
Pretty close to it.
All right, so we'll set this for a one-day jury trial about 90 days out. I will set this for a final status conference about 30 days prior to the trial date. So Mr. Schilling, you'll get a notice of that date. That'll be your next appearance in court. That will be the plea cutoff. So to the extent there are further plea discussions, that final status conference would be the last day to enter into a plea. Also, Mr. McCarty, that'll be the motion cutoff. So you're free to file any motions at any time, but any motions must be filed and heard no later than the date of that final status conference. I will put all of those dates into an order that'll go out to both sides, along with the court sending out notices of the date and time of trial and the final status conference. Mr. McCarty, anything else I can address?
I would like to address a condition of Bob Judge. He's been tested for alcohol now for, I don't know, over 3 months. It's going on 4 months. He's a combat veteran of this country. He doesn't have any prior criminal history. I don't believe that further testing in this regard is warranted. The facts of this case, the charge, frankly, Judge, and I'd ask the court to relax that condition and give me more time to operate, I suppose, as far as the 90 days. I mean, otherwise, I'd like for a trial to be like next week or something. But I just don't think it's warranted. And at some point in time, Mr. Ziegler and I stipulated that could be removed, but the district court didn't see it that way. But I'm going to renew that request this morning.
Mr. Ziegler?
I don't have any objection.
Okay, then Mr. McCarty, what I would ask is that you prepare a stipulation in order, get Mr. Ziegler's agreement on that, then I'll sign that.
Thank you, Judge.
Okay. Mr. Schilling, do you have any questions about how we're going to proceed?
No, Your Honor.
Mr. Ziegler, anything further from your side?
No, Your Honor.
Thank you, that's all for tonight.
Thank you.
I'm not sure we're hearing your docket, but Mr. Farmer is here.
Okay, let me take. This is. Yeah, Mr. Farmer, if you'd like to come forward, please. And Mr. McElroy there at the Wexford County Jail will call your case in just a moment. So we'll go on the record in People versus Farmer, file number 255130. The record should reflect Mr. Farmer's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of People, Your Honor.
Thomas Seeger, apparently on behalf of Mr. Farmer.
Mr. Seeger, how did we want to proceed in this file today?
Yeah, an offer has been extended. The client is still contemplating it. It's a difficult file in as much as it's an allegation by a person who maybe a preliminary examination was held. There are some questions about testimony that was provided. In any event, Your Honor, he's just asking for an additional jury status conference so that he can at least contemplate the current offer.
Mr. Ziegler?
Yeah, it's Mr. Farmer's first appearance in circuit court. The victim is in adult foster care placement and is somewhat mentally challenged, so I understand that that's why I'm taking the time to examine the testimony, consider the offer. I don't have an objection to the jury.
Okay. All right, so Mr. Farmer, the court will set this for another hearing in about 30 days. Between now and then, I need you to discuss any plea offers with Mr. Seeger, your attorney. And I'll need you to be ready with a final decision at that next hearing as to whether you wanted to accept any plea offers or whether you wanted to move forward with trial. Okay.
Yes.
Do you have any questions at all?
Not at this time.
Mr. Seeger, anything further? Mr. Ziegler? Thank you. That's all for today. Mr. Travis out there?
He was, let me.
Okay. All right. Mr. McElroy, we're a little bit ahead of schedule. Your attorney is with a different client at this time, so we're going to take a short break. I'm just going to ask that you remain there on the camera, and we'll get started with your hearing in about 5 or 10 minutes. We have here, Mr. Elhart.
Fortuny, Your Honor.
Okay. We'll go on the record in People versus Joseph Fortuna. This is file number 255131. The record should reflect Mr. Fortuna's presence in the courtroom today. If I say counsel, put your appearances on.
Ryan Ziegler, on behalf of TJ.
Craig W. Elhart, Your Honor, on behalf of Mr. Fortuna.
Mr. Elhart, can you tell me the status of this file this morning?
Yes, Your Honor. Mr. Fortuna is dying. I'm surprised he's made it this long. And we'd asked for a 30-day continuance. And by then I fear that he won't be with us anymore.
All right, Mr. Ziegler.
Your Honor, it's our first appearance in circuit court. I had discussed potential resolutions with Ms. Kreinbrink, from Mr. Elhart's office. I don't think we've reached any sort of resolution. I don't have an objection to a 30-day adjournment.
I guess, Mr. Elhart, under the circumstances, what I would suggest is docketing this for trial. If other circumstances intervene and we don't need it, then we don't need it.
That's immediately.
But I think if we have it on the docket, that gives us a point of resolution.
I concur, Your Honor.
Mr. Ziegler, how many days of trial do you think we would need in this case?
I think erring on the side of caution, Your Honor, would be a 2-day trial.
I concur, Your Honor.
Set it at about 120 days out with a final status conference 30 days prior to the trial date. That would be the plea cutoff and the motion cutoff. Mr. Fortuna, that would be your next appearance in court. The court will send out notice of the trial date as well as that final status conference and a copy of the scheduling order. Mr. Elhart, anything else?
Nothing, Your Honor. Thank you. Thanks for your courtesy today.
No, Your Honor.
Okay. All right. Thank you. That's all for today.
I know. I won't say it again.
Mr. Seeger.
All right, I have Mr. Farmer, I have Mr. McClintock, and I have Mr. Sherwood all here. In what order you want to take them?
Let's take Mr. McClintock's case.
Travis one.
Can you, Harry, ask Mr. Travis to come in? Okay, we'll go on the record in People versus Kenneth McClintock. This is file number 255125. The record should reflect Mr. McClintock's present here in the courtroom today. If I could have counsel with your appearances.
Ryan Ziegler, on behalf of TJ.
Thomas Figure hearing with an idea of Mr. McClintock.
Mr. Seeger, how did you want to proceed?
Your Honor, this is the first moment that we're in circuit court. Mr. McClintock has asked for the matter to be set out for a period of time so that we can further examine some issues that he had raised today. If the court gave us 60 days to file motions, that would be sufficient. So if you set it in 2 months for us to have a final settlement conference, all motions could be heard if there are any. And if we're going to accept a plea of some sort, we can accept a plea on that date and then just go forward.
Okay. Ziegler, do you have any objection to that?
No, Your Honor.
Mr. McClintock, have you had a chance to discuss this with Mr. Seeger?
Yes.
You understand that that's going to result in a delay of your case being processed. Do you have any objection to that?
Oh, sure.
All right. So, Mr. McClintock, between the next hearing date will be set about 60 days out. That's going to be the plea cutoff. So to the extent that you want to consider any plea offers, you'll need to have made a final decision and be ready with that decision at that next court date. Okay.
Yes, sir.
Thank you. That's all for today.
All right.
This is Mr. Sherwood. Sherwood, Mr. Travis.
Okay. Mr. Sherwood, if you come forward, please. The court will call. Oh. All right, we'll go on the record in People versus Sherwood, file number 255132. The record should reflect Mr. Sherwood's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of People, Your Honor.
I'm Seager, on behalf of Mr. Sherwood.
And what is the status here today, Mr. Seeger?
Your Honor, at this time, Mr. Sherwood would ask the court to set this over for a period of 30 days while he contemplates the offer. My recollection, this is his first appearance in circuit court.
Mr. Ziegler.
I don't have any objection.
Okay, Mr. Sherwood, we'll set this matter for a hearing in about 30 days. At that time, I will need you to have a final decision as to whether you want to accept any plea offers or not. So make sure that you discuss that with Mr. Seeger between now and then. And like I said, be ready with a final decision on that date, okay?
Thank you, Your
Do you
Honor.
have any questions about that?
Not at this time.
Okay, thank you. Thank you.
Your Honor, I did have one final hearing at 11 o'clock, and I can come back for it. There are warrants according to the probation department for Mr. Dennis. So
Okay.
if he does appear, I'll come back for this meeting store.
Okay.
If he doesn't, warrant that's already in existence.
Oh, there is one.
Ms. Wagner had said that there was a warrant for his arrest. Trying to confirm that with Ms. Wagner.
There might be I thought that was from a different court.
I think it was for a different court, but then because he allegedly failed to appear for his PSI, asking for him to be held. So I assume if he shows up, arguably he may be held.
Right.
Even if he's not, he's going to be held on the other warrant,
Okay.
I assume.
Either way, we'll need to go on the record. So
That's fine. You're on this meeting straight.
is Mr. Travis in court?
I'm not sure where he is, Your Honor, but I did send him.
At this point, we can't locate.
Oh, okay.
I'll call him, Your Honor.
Okay. Mr. McElroy, we're still trying to track down your lawyer, so as soon as we can find him, we'll get started with your case. Okay, Mr. McElroy, we just need you to unmute on your end there.
Oh,
Okay, and I've been calling you Mr. McElroy all morning, but I just want to confirm you are Nathan McElroy, is that correct?
McElroy, yes.
McElroy, okay, thank you. We'll go on the record in that file, that's file number 255128. If I could have counsel put your appearances in.
Ryan Ziegler, yeah, was,
Kyle Travis on behalf of, apologies, I was over in the jail and lost track of time.
No problem. Mr. Travis, what is the status of this file this morning?
Your Honor, we are here for our first appearance. There is an offer to plead to a possession of analogs with no enhancements. We did have some discussions about a 7411 plea, but in reviewing criminal history, I don't believe that Mr. McElroy would qualify. So I guess I would leave it to Mr. McElroy as to what he wants to do. We had kind of been back and forth prior to today as to what he wanted to do.
So just to be clear for the record, what is the current offer?
Your Honor, the offer is a plea to one count of possession of analogs. In exchange, the possession of narcotics and the habitual third would be dismissed. Mr. McElroy does not qualify for 74.
And the analogs is a 2-year,
That's correct, Your Honor.
and then no habitual?
Correct.
Okay. Mr. McElroy, were you able to hear that?
I was able to hear that. Why I was not able out for 7411. I've never been charged with a felony before. I've never been given that opportunity. I've never had possession of hard drugs, so I know that everybody else is out there. So why I don't fit that criteria.
And Mr. McElroy, if you'd like, I can explain to you what I'm being told on your history that would preclude you. Would you like me to do that?
Well, yeah, I'd like to be pulled out of the dark.
So it's a possession of marijuana and a use of narcotics. And if you
Neither
have
one
any
of them are felony
narcotics,
drug cases.
you don't need a felony drug case, you just need a drug case in general to be precluded.
I thought that's what the 7411 was, is whenever you're charged with a felony, that you have the opportunity to be able to probate and get that expunged from your record.
It is actually specifically to a drug charge, including formerly including marijuana and also a usage charge. So it doesn't have to be a felony. It is probably most often used in Kalkaska relative to felonies, but the statute is only available to someone who's never been convicted of a narcotics charge, including a marijuana charge.
Okay, so why was this not offered to me before on either one of them charges?
To that, I can't say. I don't know.
So it's something that's never been available to me. Is that a reason for maybe an appeal later on?
No, the issue with the 7411 is if you, it's not whether you got one before or not doesn't really matter. It just matters that you're unavailable to get it if you have certain prior things on your record.
And that's because I was unaware of this law, or?
I have no idea what happened in the past, Nathan.
Right. Well, that's I mean,
Usually when someone's offered a use or something like that, often they're not given a 7411 depending on what's going on. But that's more of a local practice issue, can be different in different counties.
All right. So where do we go from here?
That is the question today is, did you want to accept the offer, or did we want to ask the judge for an adjournment for some reason? Or did we want to set the matter for trial? Those are that's the question for today.
Might as well set it for trial.
Okay.
Okay, Mr. Ziegler, how much time do you need to be ready on this case?
Your Honor, I can be ready within 90 days.
Mr. Travis?
Yes, Your Honor. That's more than enough time.
Okay. 1-day trial?
I believe so, Your Honor. Yes.
Yes, Your Honor.
Okay. All right, so Mr. McElroy, we're gonna set this for a 1-day jury trial. You'll be notified of the date of that trial. It seems like, I mean, if I can get this on earlier than 90, if I put in the court's next available date, I mean, Mr. Ziegler doesn't look like you have a lot of witnesses.
I think I'll have 2 or 3 witnesses, Your Honor, and I could be ready.
Okay,
Yes, Your Honor, as long as we have some level of time, 60 days is more than enough,
Yeah.
I would say.
okay. All right, so Mr. McElroy, I'm gonna set this for a 1-day jury trial at the court's next available date. You'll be notified of the date and time of that trial. I will set this for a final status conference on a date immediately prior to that trial date. That final status conference would be the plea cutoff, so to the extent that you wanted to further consider any plea offers, that would be the final day to enter into any plea agreements.
Okay.
And that's how we'll go forward. Mr. Travis, anything else we need to address today?
Nothing further, Your Honor. Thank you.
Mr. Ziegler?
No, Your Honor.
Mr. McElroy, did you have any questions at all?
Nope.
Okay.
All
All right, thank you, that's all.
I can't ask Kyle, get a hold of me later or Zoom in so that we can discuss this.
Yep, definitely.
Okay. Thank you. And have a good day, guys.
Okay, thank you. Sir, what's your name?
It's Mr. Flowers, Your Honor.
Mr. Flowers. Okay, Mr. Flowers, if you want to come forward, please. Call People versus Flowers. This is file number 255115. The record should reflect Mr. Flowers is present here in the courtroom today. If I could have counsel put your appearances now.
Ryan Ziegler, on behalf of People, Your Honor.
Kyle Travis on behalf of Mr. Flowers.
And Mr. Travis, how did we want to proceed in this file this morning?
So, Your Honor, we had adjourned because there was some confusion over Mr. Flowers' criminal history and whether he qualified for a 7411. I did actually find out what had happened there. He did have a marijuana charge, and it is dismissed, but it got dismissed through the automatic expungement statute. And in speaking with Mr. Ziegler, given his limited criminal history and the fact that he was able to achieve that marijuana possession charge being expunged through the automatic expungement, it's my understanding Mr. Ziegler would offer to handle this matter under a plea to a possession of methamphetamine under a delay, and upon completion of that delay, he would dismiss the charge to, in effect, give a somewhat similar effect to a 7411 to Mr. Flowers, because he's precluded, but the charge is so old and his record was as such that he was actually able to get an automatic expungement on that charge, I think is the motivation for Mr. Ziegler for this.
All right, thank you, Mr. Ziegler.
That's all correct, Your Honor.
Okay. Mr. Flowers, have you had an opportunity to speak to Mr. Travis about this plea agreement?
Yes, I have.
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Flowers, are you currently on any kind of probation or parole?
No.
All right, and you understand that possession of methamphetamine is a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine.
Yes.
And so you understand that if you were to fail to successfully complete this delay of sentence, that you would be subject to that maximum possible penalty.
Yes.
Okay. With that in mind, what is your plea to that charge today?
I plead guilty.
Okay. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty to this charge because you are actually guilty of this charge?
Yes, Your Honor.
Okay, this happened back on October 1st of 2025. Is that the correct date?
Yes.
On that date, were you present here in Kalkaska County?
Yes.
While you were here in Kalkaska County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right at that time to have any amount of that?
No.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Counsel, are you both satisfied that the court has complied with statute and court rule in the taking of its plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Flowers, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a hearing on that delay of sentence. That'll be in about 30 days. You'll be notified of the date and time of that hearing. Make sure that you stay in touch with Mr. Travis between now and then. Ms. Wagner, does Mr. Flowers need to come over and meet with you today, or how do you want him to handle that?
If he can come over, thank you.
Okay, so after the hearing today, if you just stop by the probation office next door, they'll give you some further instructions, okay?
And Your Honor, since he's here, I did get an email from Jen that to Chris, I think there were some issues with Mr. Flowers' notice. I don't know if it was because of his address or not, but just maybe we should confirm his address.
Yeah, it's gonna be the last thing I did because I have a little note here myself, so, if we can confirm that, Mr. Flowers, your. Clerk, please.
It would be P.O. Box 125, South Boardman.
And if we send mail to that address, you'll get that.
Yes, I should. Why that didn't show up, because I have all my mail being forwarded to that P.O. Box right now, so why I didn't go there, I don't know.
I don't either, but it's better that we have, so we can send it directly, so, all right.
Thank you.
Anything further?
Nothing further.
Okay, that's all for today, Mr. Flowers, thank you.
Thank you.
Your Honor, Mr. Chance is here, but could I have just a minute to speak with him?
Yes, let's take a short break, we'll come back on the record in 5 minutes. Okay, at the jail, sir, can you tell me your name, please?
Randy Hyatt.
Mr. Hyatt, okay, we'll go on the record in People versus Randy Hyatt. This is file number 255139. And Mr. Hyatt, can you tell me what jail you're located at?
Antrim County.
Okay, record should reflect Mr. Hyatt's appearing by Zoom today from Antrim County Jail. If I could have counsel put your appearances on.
Brian says, yeah, people.
Kyle Travis on behalf of Mr. Hyatt.
Mr. Travis, can you tell me the status of this file from the defense side today?
Yes, Your Honor. Mr. Hyatt waived his preliminary exam. The offer that was made at that point was one count of flee and elude third degree, dismissing all other counts and all of their enhancements. I believe Mr. Hyatt would like to accept that plea. He and I did speak on the phone yesterday, and when he asked me what his guidelines were, I had told him a 5 to 23. After that conversation, I re-reviewed them. And as I told Mr. Hyatt, these are always just my estimations, very educated guesses, but the way it works is I don't decide them, but I re-looked at them after a phone conversation because I was remembering when I talked to him. I would say my assessment is they are a 10 to 23, Mr. Hyatt. But that is my assessment, as Your Honor knows, and Mr. Ziegler knows, the guidelines are ultimately scored by MDOC and then argued about by Mr. Ziegler and I and decided by Your Honor. So that was just my assessment, but I did say a 5 to 23 on the phone yesterday. And upon looking at it more closely, my better guess is a 10 to 23.
Okay, in terms of the plea offer, is that a correct statement, Mr. Ziegler?
In terms of the offer of not commenting on the guidelines, yes, Your Honor, it'd be one count of fleeing and eluding third degree with no other charges or enhancements.
Okay. Mr. Hyatt, were you able to hear everything that the lawyers have said here?
Yes.
Okay. How did you want to proceed today? Did you want to go forward with that plea agreement?
Yeah.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Hyatt, are you currently on any kind of probation or parole?
I'm on parole.
You're on parole? Okay.
Yeah.
So you understand that because of your parole status, number one, you would not be entitled to any jail credit in this file.
Yes.
And you also understand that any sentence in this file would have to be served consecutive, in other words, back to back with any penalty you might receive for violating your parole.
Yeah.
Okay. And did you hear Mr. Travis when he indicated that he believed his better estimate of your guidelines would be 10 to 23 instead of 5 to 23?
Yes.
Do you still wish to proceed with the plea even in light of his change in terms of his estimate?
Yeah.
Okay. All right. Then with regard to the charge in this case, the charge is one count of fleeing and eluding third degree. All other charges and enhancements would be dismissed. That means that the maximum possible penalty you could face would be up to 5 years and or a $5,000 fine. Do you understand that?
Yes.
With all of those things in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of that appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
Nope.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates that this happened on or about November 12th of 2025. Is that the correct date?
Yes.
On that date, were you driving a motor vehicle here in Kalkaska County?
Yes.
At the time that you were operating that vehicle, did a Michigan State Police trooper attempt to pull you over?
Yes.
And how did they indicate that to you that you were supposed to pull over?
Their lights.
Okay. And did you fail to pull over as directed?
Yes.
And did you in fact try to evade or flee from that police officer?
Yeah.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Oh,
Your Honor, I think one more question. Mr. Hyatt, did you actually, as part of that fleeing, end up crashing your car?
Yeah.
Oh, I see. I'm sorry, I didn't see that last sentence. Okay. With that, counsel, are you both satisfied with the factual basis?
yes, Your Honor.
Yes, Your Honor, thank you.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Hyatt, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. This matter will be set for a sentencing hearing. Is Mr. Hyatt going to be in Antrim County?
He just middle of December received a 4-month sentence there, so unless MDOC takes some action, I imagine that's where he'll be for the immediate future.
Okay, so Mr. Hyatt, you have the right to be present here in Kalkaska in court for your sentencing hearing. If you wanted to exercise that right, I would sign an order to have you transported from Antrim County to here in Kalkaska County for that hearing. You could waive that right and we could have that hearing by video as we're doing today. Do you know how you'd like to proceed on that?
I'd rather be there.
Okay, so we'll set this for an in-person sentencing hearing here in Kalkaska. Mr. Ziegler, I'll ask that you prepare a writ for Mr. Hyatt to be transported here.
Yes, Your Honor.
Mr. Hyatt, somebody from Department of Corrections will meet with you between now and that sentencing hearing for a pre-sentence report, and then you'll have an opportunity to go through that with your attorney prior to the sentencing, okay?
All right.
Thank you. That's all for this hearing today.
All right.
Are you ready on Mr. Donald's file?
We are, Your Honor.
People versus Chance Donald, file number 255140. The record should reflect Mr. Donald's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people.
Kyle Travis on behalf of Mr. Donald.
Thank you. Mr. Travis, can you tell me the status of this file today?
Yes, Your Honor. We did waive the prelim on an offer to 1 count of delivery of methamphetamine, 1 count of delivery of narcotics. Today, we would be asking the court for an adjournment. There's a couple reasons for that. I'd like to discuss with Mr. Ziegler about HIDA. He's not supporting that, but given Mr. Donald's age, I'd like to inquire as to whether he would actually qualify for that and making that request. And the other issue is in speaking with Mr. Ziegler, there may or may not be some charges in Gaylord, Otsego County. As I've discussed with my client, I can't get any definites on that, but I can try and make some inquiries about that because it would affect what happens to him drastically. But as I clarified to him, they could tell me they're not going to charge and turn around 6 months from now and charge him, but I'd still like to make that inquiry. And we just found out about that a couple days ago.
All right, so how much time are you asking for then?
At least 30, if the court would honor it, 60 days.
All right, Mr. Ziegler.
Your Honor, I don't have an objection to that. These are obviously serious charges, but Mr. Donald has appeared at all his court dates. I don't have an objection to 60 days if the court is willing to give that.
All right, I think, you know, if the request is 60 days, I don't have a problem with that, but I would like to get this docketed for trial then. Just so that it doesn't, you know, have any further delays past that 60-day period. So if we were to set this for trial like 4 months out, 120 days, and then set it for a plea cutoff in 60 days.
Yes, sir, I think that would be appropriate.
Do you have any objection to that, Mr. Ziegler?
No, Your Honor.
If we were to have a trial in this case, Mr. Ziegler, how many days do you think?
Your Honor, I think we could probably get it done in one, but I would err on the side of two, just given the amount of charges.
Any objections?
I wouldn't disagree with that assessment. It may only take one, but I'd be leery to only give us one.
So we'll set it for a 2-day jury trial, about 120 days out. I will set this for a plea hearing in 60 days. So Mr. Donald, about 60 days, that's gonna be your next hearing in court here. You'll be sent notice of the date and time of that hearing. It's important between now and then that you stay in touch with your lawyer. Because at that date, I'm gonna be asking whether you want to enter into any plea agreement, and you'll need to be ready with the final decision on that day, okay?
Okay, sir.
Mr. Travis, anything further today?
Nothing further, Dave. Thank you, Your Honor.
Mr. Ziegler?
No, Your Honor.
Mr. Donald, do you have any questions about how we're gonna proceed with your case?
No, sir.
Thank you, that's all for today.
Thank you, Your Honor. I think that is my last matter, Your Honor.
Yes, thank you. Looks like Mr. Trepanier's file. Mr. Trepanier, are you able to hear me okay?
Yes, sir.
Okay, and let's see. Okay, Hogeboom, if you can unmute, thank you. All right, are you ready to proceed?
Yes, thank you, Judge.
All right, so we'll go on the record in People versus Richard Trepanier. This is file number 244891. The record should reflect that Mr. Trepanier is present today by Zoom video. I'm picking up a little bit of background noise, Mr. Trepanier, so I'm going to mute you, but if you want to be heard, just raise your hand and I can unmute you. But Mr. Trepanier is present by Zoom video. If I could have both counsel put your appearances on, please.
Your Honor, Ryan Ziegler on behalf of People.
Good morning, Your Honor. Diane K. Hugginson on behalf of Mr. Trepanier, who appears in video conferencing.
All right, thank you. This is the date and time set for a hearing on defendant's motion for a new trial. I did receive the motion and brief from Ms. Hogeboom. I had a chance to review that. I also received Mr. Ziegler's response. This is the time set for oral argument. Ms. Hogeboom, anything you wanted to state for the record in support of your motion today?
Your Honor, I don't really have anything beyond what's contained in the motion itself.
Thank you, Mr. Ziegler.
Your Honor, I would just say, largely rely on my brief, but I would just say that there's really nothing that any trial counsel could have done in the face of the evidence that would really stand a likelihood of a different result in this case. I would ask the court to simply deny defendant's motion without further hearing. If the court thinks there's some arguable merit to either the defendant's position, I would ask the court to set that into a hearing, but I don't think it needs to get to that. Thank you. Okay,
So the court is reviewing this motion for new trial pursuant to MCR 6.431. The court notes that it was timely filed and there hasn't been any challenge in terms of the timeliness of the motion. Pursuant to 6.431 sub B, the court can grant a motion for a new trial on any ground that would support appellate reversal or where the court believes there's been a miscarriage of justice. Here, the argument is that there was ineffective assistance of trial counsel and that would support appellate reversal and justifies a new trial in this case. The defendant is asking either for the court to grant the new trial or grant a Ginther hearing so the court can expand the record in terms of the ineffective assistance claim. Whether to grant a new trial is a matter that's within the discretion of the trial court. And whether to grant a Ginther hearing likewise is within the discretion of the court. In terms of the Ginther hearing, the burden is on the defendant to establish a need for a Ginther hearing. The defendant must make a showing that further development of facts separate from the record or in addition to the record at trial is necessary in order to advance an ineffective assistance claim. So the court is exercising its discretion in ruling both on the issue regarding the Ginther hearing and overall with regard to a new trial. In terms of the standard for ineffective assistance of counsel, the defendants set that forth in the brief, and I believe it's a correct statement. The defendant has a right to counsel. It's guaranteed by the Michigan and federal constitutions, and both of those encompass the right to effective assistance. Effective assistance of counsel is presumed, and the defendant bears a heavy burden of proving otherwise. In order to prevail on a claim of ineffective assistance of counsel, a defendant must show, number one, that the counsel's performance was deficient and that deficiency prejudiced the defendants. In other words, that the performance of counsel fell below an objective standard of reasonableness and that it had an effect on the outcome, and that it's reasonably probable that if there hadn't been that error or ineffective assistance, the result of the trial would be different. In this case, the court finds that the motion doesn't raise any issues that would require expansion of the record or further development of facts separate from the record below. So the court finds that the burden to grant a Ginther hearing has not been met, and the court, again, in its discretion, will deny the request for a Ginther hearing. In terms of the ineffective assistance claim in general, the court finds that the record below does not establish a claim for ineffective assistance. I note, number one, that I did review the record. The court did preside over the trial, so I'm familiar with the evidence that was presented and the witnesses that were presented and the testimony that was heard. One of the basis for the claims was that trial counsel should have called an additional witness, an ex-fiance of the defendant who could testify as to the defendant's living situation and where that landed him in terms of the age of the victim at the time of the alleged assault. And in particular, that the victim must have been 16 given where the defendant was living at the time. Number one, this is a claim that the court finds was fleshed out at trial. The defendant did present other witnesses as to the timeline and the age of the alleged victim at the time of the sexual assault. So the court finds it generally would have been cumulative evidence, not really new evidence, different evidence. But ultimately, the court finds that any testimony from the ex-fiance in this case wasn't such significant or, kind of smoking gun kind of testimony that it would have been unreasonable for trial counsel to conclude that whatever the ex-fiance had to offer either wasn't going to be that helpful or that different from what other witnesses were testifying, that it wouldn't have helped the case. And so the court finds that to the extent that it was trial strategy, that it wasn't unreasonable given all the other evidence in the case and given the fact that the defendant made statements to police essentially admitting that he had sexual relations with the victim when she was under the age of 16. So again, the court finds that it wasn't unreasonable for trial counsel to decide not to call that witness. And even if that witness had been called, the court finds that it wouldn't have made, there isn't a reasonable probability that it would have made a difference in the ultimate outcome and the verdict of the jury. The other basis was that the trial counsel should have engaged a police interrogation expert, and that it was error for the trial counsel not to do so. Again, for the same reasons, the court finds that it was reasonable for trial counsel, given the fact that the entire interview, with the exception of parts that both sides agreed shouldn't be played for the jury, was played for the jury. That to the extent that an interrogation expert would even conclude that there was things that were improper, that would have been helpful in light of all the other evidence. And so again, the court finds that counsel's failure to call that witness was not outside the range of reasonableness, and it's not reasonably probable that had that witness been called, that it would have made a difference, given that the jury got to see the interview itself, got to see everything that both the detective and the defendant had to say. So for all those reasons, and again, in the exercise of the court's discretion, the court finds that the motion should be denied. And Ms. Hoagland, I'll just request that you prepare an order reflecting the ruling of the court today for the reasons stated on the record, and submit that pursuant to the 7-day rule, or with a stipulation as to form from Mr. Ziegler.
Certainly, Your Honor.
Okay. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time. Mr. Isles, are you ready with your client?
Yeah.
We can take your case early if you'd like.
I was planning on spending a half hour basking in your presence, but okay.
Right. We'll go on the record in People versus Ogden. This is file number 255138. Reflect Mr. Ogden's present today in the courtroom. If I could have counsel put your appearance.
Scott Isles on behalf of Patrick Ogden, who's to my left.
Mr. Ogden, if you'd like to come right up to the podium there, please. And Mr. Isles, can you tell me the status of this file from the defense?
We're going to go to trial.
Okay.
I've
And
talked to the prosecutor about it. We expect 2 days.
okay.
I will have between 3 and 5 witnesses. There'll be several exhibits.
And Mr. Isles, how much time would you like to have before the court sets this for trial?
Well, there's still some discovery to be had, and I understand the prosecutor is going on vacation this month. I'm going to be gone the first week of February, and probably the last week of March. So sometime after March would be great.
Okay. Mr. Ziegler, do you have any objection to that?
I would agree that we need at least that much time, Your Honor.
So we'll set it for a 2-day jury trial in April. I will set this for a final status conference prior to that. That final status conference will be the plea cutoff. Mr. Isles, are you anticipating any pretrial motions being filed from your side?
No, Your Honor.
Mr. Ziegler?
No, Your Honor. Mr. Isles and I are discussing a stipulation as to certain facts, so we'll hopefully get that to the court once we complete all the discovery and work out some other issues.
Okay. All right. So, Mr. Ogden, your next hearing in court will be a final status conference that'll be shortly prior to your trial date.
Yes, sir.
That will be the plea cutoff. So to the extent there are any plea discussions, that would be the last date to enter a plea. To the extent either side does have motions, they need to be filed and set for hearing no later than the date of that final status conference. The court will send out notice of that date, as well as the trial dates in April. Mr. Isles, anything else I can address for your side?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Mr. Ogden, did you have any questions about how we're going to proceed?
No, Your Honor.
Okay. Other Other than that, just make sure you stay in touch with your attorney so that you can be prepared to move forward. And that's all for today. Thank you.
Thank you, Aaron.
All right. Our next hearing is Mr. Dennis at 11 a.m. So we'll take a short recess until that. Go on the record in People versus Lloyd Dennis. This is file number 255118. The record should reflect Mr. Dennis is present here in the courtroom today. I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people here.
Thomas Seeger appearing with, and I have Mr. Dennis.
So this was set for a sentencing hearing today. I did receive a report from Department of Corrections indicating that they attempted to go forward with the PSI process. We're not able to make contact with Mr. Dennis. Seeger, do you have any additional information on that?
Yeah, just speaking with Mr. Dennis was on probation with Ms. Wagner, and I think that he, at least his description is that he inadvertently did not understand that he needed to complete the PSI because he was already on probation with Ms. Wagner. So, taking into consideration what he was indicating, he essentially said that it was a good faith error. It's my understanding that there's some kind of outstanding warrant in Benzie County for some other matter, but that really has nothing to do with our matter. I guess, like, from my vantage point here, I was just trying to figure out how to maybe address the completion of the PSI, which would allow him to resolve whatever he needs to take care of in Benzie. I guess my concern would be that if he, I'm not sure what they're going to do there, so I don't know what will happen in terms of credit. I don't want to get the postscript from the bond here, so maybe can post that if he can post it or resolve his other bond in Benzie County. That would be helpful as well, but I don't really know exactly how it's going to go for him.
Do we have a current bench warrant here? I don't think we do.
Don't show.
Ms. Wagner, can you, I know you submitted that case report to me. Can you just, for the record, tell us the efforts that you made to reach Mr. Dennis?
Yes, Your Honor, I made multiple attempts to contact him by phone, multiple times. He ended up failing to report for his scheduled report day, which ended up in a bench warrant in Benzie County. So that's what he's got pending right now. But he's made no attempts to reach out to me for this PSI process.
Mr. Ziegler?
Your Honor, I think at this time, and I don't know what it will mean in terms of his credit, but I don't know that it's really the court's concern at this point. He failed to comply with his probation in Benzie. He failed to appear for the PSI process. I think we need to complete that process to proceed to sentencing. I think Mr. Dennis should be held by this court until such time as the PSI can be completed the sentence.
All right. So, Mr. Dennis, in light of your failure to cooperate with the pre-sentence work process, I didn't understand what we're supposed to do. Given that the report also indicates that there's been a failure to submit to the weekly drug screening, which is part of your bond conditions, in light of the fact that there's already been a plea entered, I am going to order that your bond in this file be revoked and that you be held until the court can get this set for sentencing. Ms. Wagner will contact you at the jail to go forward with the pre-sentence report process. Mr. Seeger, I'm happy to entertain whatever orders you would like to submit so that Mr. Dennis gets credit for the time that he's lodged.
I think he gets credit, Your Honor, to the extent that he can't post his bond. Presumably he'll get credit, and then I'll have to see what's going on with Benzie County. As the court is aware, there's just, if he's under sentence somewhere, that makes it more difficult.
Right. Okay. All right. So that's how we'll proceed. Mr. Seeger, anything further on this file today?
No, sir.
Mr. Ziegler?
No, Your Honor.
Okay. All right. The court will issue an order revoking the bond and remanding Mr. Dennis to the Kalkaska jail for purposes of this file. And our next hearing is at 11:45. We'll be in recess until that time.
Thank you. Yeah.
I don't know if he'll even show up, so.
All right, Mr. Storrs, are you able to hear me okay? All right, so we'll go on the record now. This is People versus Grant, Wheezy, case number 13-3580. The record should reflect that Mr. Wheezy and his counsel, Mr. Storrs, are present by Zoom video. We have Mr. Ziegler here on behalf of the people in the courtroom. This is a hearing for an application to set aside 3 different convictions that were entered against Mr. Wheezy back in November of 2013. I did have an opportunity to review the application and the file generally. I know we did receive a report back indicating that there aren't any other current matters involving Mr. Wheezy. And a ruling or an opinion from the the Attorney General indicating that the only issue might be with regard to the license, operating while license suspended. I don't think any of the exemptions apply to that. Mr. Ziegler, would you agree?
I would agree, Your Honor.
So I think from a statutory standpoint, Mr. Wheezy's eligible to have the conviction set aside. Mr. Ziegler, would you agree with that?
I would agree that he meets the technical requirements, Your Honor.
Okay, so what that leaves, Mr. Wheezy, is 2 additional findings by the court. Number 1, that your behavior and circumstances since these convictions were entered would warrant having them set aside, and that it would be in the public interest to do so. Mr. Storrs, I usually leave that up to counsel to conduct some questioning of your client as to those last points. Are you prepared to do that today?
Yes, I can, Your Honor.
Okay, Mr. Wheezy, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Thank you. You can lower your hand, and Mr. Storrs, please proceed.
Very good. Very good. I'm going to talk to you. I'm going to talk to you so that I'm going to try to talk slow. We're getting a lot of echo back. We're getting a lot of echo back and forth.
Yeah, your audio isn't coming through real great here. So yeah, if you can talk slow and take breaks in between when the 2 of you are talking, that would probably help.
Okay. Okay. Grant, you state your full name for the record? State your full name for the record.
Yes, Grant Cameron.
Yes, Grant Cameron. And since these convictions in 2013, have you had any other convictions?
No, sir.
Have you been arrested for any other issues at all?
No, sir.
No, sir. You currently have a valid driver's license?
Yes, I do.
Yes, I do. And since 2013, has your style changed?
Yes, dramatically.
Yes, dramatically.
I've started a business.
And what is that business?
Construction, we do residential.
When you say a family, are you now married?
I am married with a wife and 4
And regarding the benefit that Judge mentioned, I would expungement or set aside a conviction benefit your role in society.
Mainly lift the weight off myself. Make me feel more present in living situations as well.
Mr. Storrs, I wasn't really able to hear much of what Mr. Wheezy just said there.
Yeah, just being a parent, more available and not have anything hold back, as well as my business. I want anybody to look at that as bad example of myself.
Can you tell me again what business you're involved in?
We do construction work, so framing and interior work, and commercial.
Okay, thank you. Go ahead, Mr. Stores.
And you have concerns that this criminal history would cost you clients?
Yeah, exactly. If someone were to look at me that have felonies, that can't be hired.
I have nothing further, Your Honor.
All right, Mr. Ziegler, do you have further questions, or do you take a position on whether the court should grant the relief based on the testimony here today?
I don't have any questions, Your Honor. I think that given the passage of time and given the relatively low severity of the crimes at issue in this case, and given that Mr. Weezy apparently has been involved in a successful business that is benefit to the community and expunging these offenses, it seems like Mr. Weezy has taken these matters seriously. He's changed his life. He hasn't had any appreciable issues in the meantime. I support the relief being requested.
Thank you. Mr. Stores, anything further you wanted to say today?
Oh, Your Honor, thank you.
All right. Again, I do find that Mr. Weezy has met the technical requirements to have the conviction set aside. I do find that his behavior and circumstances since the convictions would warrant having them set aside. These convictions were entered a little over 12 years ago at this point. The court notes that they were convictions involving marijuana, which is now, of course, recreationally legal within the state of Michigan. So they don't involve other more serious substances. The court finds that it would be in the interest of the public generally for Mr. Weezy to be able to carry on his business and not have it be hampered by convictions such as these, which are older and again, which involve marijuana, which is a less serious substance than some of the others out there. The court also takes judicial notice of a general scheme of the legislature providing for more opportunities for individuals to have convictions such as these expunged from their records so that they can move on with their lives and not be hampered by old convictions from their past when their lives have clearly changed as indicated by Mr. Weezy at this time. So for all those reasons, the court finds that the application should be granted. Mr. Stores, I was looking through the file. I did not see, did you submit an order setting aside?
Thought I had, but if not, we can get that sent today.
I did not see that. So yeah, if you will submit an order setting aside, then I'll sign that once it's presented.
Thank you, Your Honor. Thank you, Mr. Ziegler.
Okay, thank you. That's all for today, and you're free to disconnect.
Thank you.
Have a good day.
That concludes our morning docket. The court will be in recess until 1:30.